A financial agreement is an agreement entered into by couples in Australia which details the way they wish to have their assets, their financial assets, divided in the event that they separate. So all Australian couples can enter into such an agreement, whether it be prior to or in anticipation of a marriage or anticipation of entering into a de facto relationship, during such a relationship, or indeed at the end of such a relationship. The important thing to note is that the terms of the agreement don't operate until the parties have separated. Agreements can deal with all sorts of assets. They can deal with real estate, investments, shares, personal property, and indeed superannuation. So there are technical agreements, and the requirements have to be followed strictly, otherwise they won't be binding. But provided they are followed, the technical arrangements, then they will be effective to divide the parties' assets once they have separated. A distinguishing feature of financial agreements is the fact that before they're entered into, both parties must have independent legal advice as to certain matters which are set out in the Family Law Act, and the solicitors who give that advice must sign a statement to say the advice has been given. A wide range of things, really. Usually such agreements cover the division of the parties' assets. Now, and that can include, as I've indicated, real estate, investments, shares, and superannuation. One important feature which can be covered in a financial agreement is the parties' attitude to spousal maintenance if and when they separate. And it can provide, an agreement like that can provide for a payment of spousal maintenance, or indeed a prohibition against a payment of spousal maintenance. And often when parties are dividing up their financial wealth, the question of ongoing spousal maintenance is very important and needs to be addressed. A big factor also is the division of superannuation. Superannuation in Australia, of course, has become extremely important in terms of parties' wealth and will continue to be so. And an agreement provides a way of dividing or splitting superannuation so that superannuation can be taken from one spouse and given to the other spouse as part of an overall division of their assets. They are binding, provided the technical requirements have been met. The major one, as I've indicated, is that both parties must receive independent legal advice prior to signing the agreement, and the solicitors who have given that advice must sign a statement to that effect. The advice is specified in the Act as to what must be covered, and if it's not covered, then the agreement won't be binding. Further, if you are seeking to set aside or block any claim for spousal maintenance, there are certain other technical requirements that have to be met. Obviously the documents have to be signed by both the parties and witnessed, but it is important that when you are thinking of entering into such an agreement that you do get the appropriate advice by someone who has experience in dealing with financial agreements and family law generally, because we come across agreements that unfortunately haven't been properly prepared according to the technical requirements, and they can be set aside by the court.